if a person who owns a house or a site or land gets a visitor, in the sense that somebody comes into their house or onto their land, etc., which they invite on, they have a duty of care, which means that if that person coming into your house or onto your land gets injured, you may be liable. Secondly, you may be liable. Now, the people who come onto another person's property, come into their house or onto their land or pass over their land, they're divided into two categories. The first category is they're either a trespasser or a recreational user. A recreational user would be a person who's walking through your farmland, usually, while on one of those hikes or just rambling. They're in the same category as trespasser, and you owe the same duty of care to them as you would to a trespasser. And a trespasser can include somebody who's on your land without your permission and that you wouldn't wish him to be there, or alternatively somebody who's actually broken into your house with the intention of committing a crime. Now, first of all, your duty of care to trespassers and recreational users, it was changed about a year ago. And it is changed in a way that benefits the occupier. It's harder now for a trespasser to get damages. The only requirement on the occupier, the obligation of the occupier of the house, of the house owner, is that you don't intentionally injure the trespasser or act with reckless disregard to his safety. An example of that would be if you had a large hole dug in your front garden or whatever, and you knew that somebody coming in was likely to fall into it, and you didn't do anything about it or put up a sign or whatever, that would be regarded as recklessness. But it is a pretty high level of pretty high onus of proof. Secondly, the other category is visitors. Now, a visitor is somebody you allow into your house, a next door neighbour dropping in for a cup of tea or a chat, or somebody calls in, and somebody calls to the door, say as a salesman or whatever, and you invite, or a canvasser, and you invite them in. Your own children are regarded as visitors in law. If you have land, we'll say probably outside the city, and you charge people a fee for the privilege of going over that land, you elevate them then from being a recreational user stroke trespasser to being a visitor, so you owe a higher duty of care. The duty of care that a householder will owe to anybody that he allows into his house is that he takes all reasonable care to avoid any foreseeable risk to that person. And that's decided on a case-by-case basis by the courts. But last year, the law was tightened up in this regard. The wording was changed to make it more difficult for a visitor to succeed in an action for damages. The court is now, when making a decision on whether a duty of care has been breached, they have to consider they are legally obliged, the judge will be legally obliged to consider other matters, such as the potential severity of the injury, the cost or practicality of taking further remedial measures to alleviate the danger, various things like that. There's a number of things they must look at, which will make the hill higher for the person who's seeking damages to climb. Just to go back to trespassers for a moment. Now, anybody would imagine that if somebody breaks into your house with the intention of robbing you or committing a crime in your property, breaks in as a trespasser, that they get injured, that you shouldn't be liable in damages to them, that you couldn't successfully sue you for damages. Now, the old law, before it was changed last year, said that the court can award damages to a trespasser in such a case if the interests of justice require it. And that was a very broad. It was a very broad statement. I don't know if any of those category of trespassers was ever successfully sued, but it was tightened up further in the legislation last year. So, in order to be liable now to a trespasser, you must either intentionally injure him or act with total disregard to his safety. The judge has a final discretion which states that looking at all the facts of the case, how the trespasser behaved, the nature of the danger, how the occupier of the house reacted or how he responded or how he conducted himself, they can look at all that, and in the most exceptional circumstances they might give damages to a trespasser. But if I was back practicing law, I wouldn't like somebody coming into me seeking to get damages from a householder when they broke into his house with a view to robbing him, it's going to be extremely difficult. Now, an issue that arises quite often is warning signs. What is the effect of a warning sign? If you put up a sign warning somebody there's a danger, well, the warning sign can certainly reduce the level of damages, and in some cases it can remove liability altogether, but it must be prominent, it must indicate the exact danger to be negotiated. It must be quite specific, and it must be in a place where somebody coming onto the property will obviously see it. For example, you can't put it down a laneway where you get maybe 10% of people calling to your house call and ignore the other 90%. A general notice is, visitors enter at your own risk. That would not be of itself sufficient, so it doesn't guarantee that you won't be liable. The other thing to bear in mind in relation to liability of householders or farmers or people who own property is if the person who is injured, if the person who goes onto your land as a trespasser, as a visitor or whatever, is a child, the duty of care will be higher. Take, for example, a warning notice. A child mightn't appreciate a warning notice as much as an adult. A child mightn't appreciate potential danger as much as an adult. So basically, they're just the general rules. I can't give you any specific instances. There's plenty of case law under the old legislation, but I've been looking around. There's been no decided case yet based on the new legislation, but it certainly, reading through it, it certainly makes it more difficult for visitors or trespassers to claim damages against a householder or farmer.